Hi there, this is Jonathan Ginsberg. I'm a Social Security attorney here in Atlanta, Georgia. I want to talk to you today about something called the GRID rules, or otherwise known as the medical-vocational guidelines. And I've talked about this a little bit before, but I wanted just to kind of reiterate the importance of always looking at the GRID rules and telling your attorney to look at them. You never know when they may apply. And specifically, if you're over the age of 50 and you have some sort of a physical limitation, the GRID rules may apply. Now, obviously, when you look at the GRID rules, they're going to really apply more to people who have unskilled work background or no transferable skills, or someone who's got very limited education, but it's always worth taking a look at them. So if you're over the age of 50, big picture, you want to tell your attorney, take a look at the GRID rules, medical vocational guidelines, and see if I qualify. Basically, the GRID rules, what they're designed to do, it's a reflection of the fact that people who are over the age 50 are going to have a more difficult time finding work in a competitive economy. And really what it says is that even if you have the capacity to do certain types of physical work, you're still disabled because no jobs are out there for entry-level jobs for a person who has limited skills and limited education. And it's interesting to see that sometimes judges are not even aware of this. And I'll give an example. I had a case just the other day where my client is age 61. He has an 11th grade education, and his past work was 15 years. Within 15 years, he only had one job, and that was for about 3 or 4 months. He had $1,000 of earnings 14 years ago. So in effect, that means he had no work. That's really what that means. So I was preparing my case, and I'm looking at it, and I'm thinking, this guy meets the GRID at medium, which meant that he was disabled even if he could do medium level work. And medium work is standing and walking 6 out of 8 hours in a day and lifting 25 pounds frequently and 50 pounds occasionally. Well, that's pretty heavy duty work. I mean, if you can do that, you could still be found disabled. And in fact, I think he met that. I'm giving my opening statement, and the judge interrupted me and said, nobody qualifies at medium. I said, well, Your Honor, with all due respect, take a look at the GRID rules. And so he stopped and did. He said, I stand corrected. You're right. There are a couple of situations where somebody can be qualified at medium, where even if they can do medium work, they're still disabled. And we went through, and sure enough, that was what the judge is going to decide this case on. So even the judge, who's normally very prepared, a bright guy, didn't know that there are 2 instances under medium where a person who can do medium work can still be found disabled under certain circumstances. And this is the only case I've ever had like this. This judge said the only case he's ever seen like it, but it can happen. So always take a look at those GRID rules. Always have your lawyer take a look at them. If you want to see them, I've got a website I put together called gridrules.net, gridrules.net, gridrules.net. And you can look at the different GRID rules and see if you qualify. But it's a very shortcut way to get approval. It's one of the 3 theories of disability you can use, the other 2 being functional capacity and meeting a listing. But if you can qualify under the GRID rules, a lot faster way to go, and can make life a lot easier and a lot quicker for you and for your attorney. So anyway, I hope this has been helpful. I hope that my experiences will be helpful to you. Any questions you've got, let me know. Contact me by email or comment on this. More than happy to try to help you any way I can. Again, my name is Jonathan Ginsberg, and I'll talk to you soon.